KJ Bonation, shaming of Jay. He's not a dopey dumb bitch. He gets laid. The court jester, the court DJ. It's time to dive into the case. To the case.
What's up, everybody? Good morning, good morning, good morning. What's up, Joanne? Carrie 28, Cindy, Donnie, Elizabeth, Betty, Tracy, Jess. Watches Charlotte, To Misha, Sarah, Munira, Stevie. Good morning, guys. CH, Rebecca, Mary, good morning. Dawn, good morning. I'm looking for this feed, but I don't see one yet, so I hope that it... Oh, and there it is, folks. Sweet. Here we go. Squaducho. Thought I was getting nervous. Thought it was going to be a problem, but it is up. So, oh, Tracy Smith coming in hot super early with a $5 super chat. Tracy, thank you so much. That was really so kind, Tracy. Thank you, thank you, thank you. Charlotte over on the kick machine. So let me go over to this hearing. Squaducho. There we go. All right, so while we're waiting, let me give you a little preview of what's going on today.
That's why I came over here to
I could probably say. Oh, Rachel, gifting out 5 memberships? Holy crap. Rachel, thank you so much. Let's see who gets them. Capri Sun's in the chat. Shannon gets one. Dawn gets one. Mimi27 gets one. Bombshell gets one. Patty C. Thank you so much, Rachel. You're so kind. Thank you. And then right after that, Joanne, who's the best. We love you, Joanne. Gifts out a membership. And Stacy gets it. Thank you so much, Joanne. You guys are so awesome. Thank you. You guys are the best. Thank you so much. Make sure the full screen here. So this is the Shanna Gardner appearance that was adjourned last week or like a week ago.
Now we're going to go to 4. Here's everything.
Guys, if you know nothing about this case, the similarities to the Dan Markel Adelson case are striking. Happy Friday. Thank you, Rachel. Who's here? Who else is here? Who didn't I say good morning? Good morning, KJ. Good morning, Shannon L. Good morning, Mimi27. Good morning, Bombshell. Good morning, Karen Lisk. Oh, Botrix woke up. It's a Festivus miracle. Tracy K is here on the kick machine. Shannon L. Gifting out a sub to Elizabeth Whitney. Shannon L., thank you so much.
Because I'm going to fuck with you, buddy. We're going to be buddies. We're going to be pals. We're going to wrestle around.
Guys, so if you're not familiar with this case, this is another case, a divorce, a super contentious divorce. An ex-wife hires, and her new husband hire a hitman to kill her ex-husband. Like another 800-page divorce file. Issues with religion. I mean, hi, Christine from Australia. Good morning, Kelly. Good morning, Brady Starr. Good to see you. Good morning, Lily Pauly. Good morning, Elspeth Hughes from England. Thank you all so much for being here, guys. Anne, hello. Yes. I sent Joel that I appreciate Joel giving me the shout out on the Surviving the Survivor. I sent him the Zoom of the Cain Velasquez. I also sent him the Zoom of the other day of the Donna Adelson hearing, and it was very nice of him to shout me out. So thank you, Joel, for that. Mary M., good morning. Mary, good morning. What was I going to say? Guys, rich parents, right. Shanna had rich parents who won't allow the kids to see the other grandparents. Karen, good point. Another thing. Shanna's, or Shana, her parents are super rich. They have like some stamp company, some like crafting company, but some people say it's like a MLM. MJ, good morning. Thanks for being here, everyone. Hot Jess, good morning. Yes, guys, and if you didn't see, let's put it up on the screen here. Let me put it up. Thank you for reminding me, Jess. Squadushel. 13K, folks. We have hit 13K. Thank you all so much for spreading the word. If you enjoy the channel, let people know. Good morning, Granny Juju. Good morning, Peter Pan. 13K, folks. Thank you all for your support. Appreciate everyone, the likes, the comments, the shares, all that you do. Paulie 3, good morning. Guys, at 10 o'clock, regardless of this is going on, we are going to the Michelle Troconis trial only because, if you didn't see yesterday, banana sandwiches, and thanks Lizbeth, who always keeps me up to date on these cases. Make sure you followed her. Excuse me. In the there's Jose Fernandez. So they're both going to be here. At the the other conspirator? The other conspirator. Babes coming in out here saying Jose Baez when I'm not talking about Jose Baez. They're both in the hearing, apparently. Good morning, Erie. Or Irie. I'm not sure how to pronounce that. Good morning, Sarah. What was I going to say? Oh, at 10 o'clock, we are going to the Michelle Troconis. I'm not covering really the trial today, but in the morning, there is possibly a contempt hearing against Michelle. Oh, Mario Fernandez. I'm sorry. Thank you, Ann. Ugh. All right. Mandy's here. Apparently, Michelle Troconis yesterday was tweeting and was pulling up articles on her computer that the gallery could see that were like against an expert witness. Additionally, allegedly, her sister was mouthing things to the jury. So there's like a contempt hearing today at 10. So at 10, and the judge apparently was super pissed. Obviously, like, why wouldn't he be? So we will be going over at 10 a.m. to Michelle Troconis to see if someone's going to be held in contempt. As far as I'm concerned, if Michelle Troconis was doing that, pulling stuff on her computer, throw her in jail. Get her ass in jail. So that'll be at 10. And then at 1:30, I'm so excited to interview Jared Ross, guys. He was a friend of Dan Markel. He went to high school with Charlie Adelson. He was friends with Dan when he was with Wendy. This man you've seen him on Court TV. You've seen him on Surviving the Survivor. Super cool dude, and I'm so excited. He DM'd me about the interview I did with Katie, and I was like, hey, man, it would be an honor if you would come on with me, and he said he would. So that's at 1:30 Eastern. Good morning, Natalie. Good morning, Sophia. $5 super chat. Well, let's test it. Let's see if it works. Thank you so much, MJ. Let's see if the robot says it for Donnie.
I said money! Money! Bing bong to test the money machine for Donnie boy.
That was so kind of you, MJ. You're the best. And you hear that, Donnie? It worked. The robot worked. Good morning, Mia. Ann says, I honestly don't know how you talk and read the chat at the same time. I could never. It's been a learning experience. Sometimes I miss stuff. Sometimes I running all this stuff in the behind the scenes. Luckily, we have awesome mods who help me out, especially who take out some of the garbage that sometimes is in here. Not often, but mods are always awesome. Always appreciate that work. I always got Babe who's helping me out. Good morning, Beachy Stacy. Thank you all so much for being here, everybody. We hit 13K if you missed it, so thank you all. The next big one I'm excited for, 15K, folks. On our way to 15K. Good morning, Christy Marie. Just waiting here, folks. And if you're on the replay, good morning, Skocky Lou. Good morning. If you're on the replay and you come at me that like, oh, I don't like how you say good morning to everyone. I don't like how you say hi to everyone. There was all this fluff and no hearing. Guess what? I don't talk when the hearing is going on, but I don't control when the hearing starts. So I can't just start my live stream when the hearing starts and then like you're just waiting. Like people were giving me crap about the Cain Velasquez stream that like there was so much stuff before Cain. That's not my control. All right, here we go. What's up, Phil? Phil is here.
Good morning.
May I be seated?
There's Mario and there's Shanna or Shanna. Someone tell me. I don't know. Fuzzy Puff, what's up? Here we go.
Good morning, Honor. Patch Brody for Miss Gardner, who's present, and Mr. Bias and Mr. Sullivan are on Zoom listening in.
Good morning.
Good morning. Wait a minute. Who is that?
That looks like a guy from Fields Automotive.
All right.
Doobies, gummies, doobies, poo, thanks.
I got it.
All right. Okay.
Thanks, Donnie.
Where's Mr. Byers?
Mr. Bias is in a
Okay.
place where
I thought
he's
you
not
said
able
he
to.
was on Zoom.
He's listening, Your Honor.
Oh, okay.
Yes, sorry about that, Judge.
Okay.
I will be speaking the least today.
What's up, Kiefer?
There was a gentleman from Fields Automotive, and that didn't look like you. Okay.
No, it's not me.
Okay. All right. On my desk, there's a defendant's motion to schedule evidentiary hearing and memorandum of law.
Yes, Judge.
Obviously, it just got placed here, so I haven't read it. I was trying to read it quickly. Do you want to give me just a moment?
Yes, Judge, that's fine.
Okay.
Drew is here. Good morning, Drew. Thanks for being here, everyone. Again, at 10 o'clock, we will switch over to see if Michelle Troconis will be held in contempt, and I hope so. Mandy's here. Stevie's here. Thanks, everybody, for being here. Kiefer's here. Ollie Selt is here. Good morning. KJ says it's too early to be cranky. Madam, it's never too early to be cranky. Good morning, Deja. This hearing, I believe, is because the last hearing was adjourned because they were waiting for something, but I could be wrong. I agree, Cindy. I agree. Fireworks in the Troconis trial. Fuzzy Pup with a $4 super chat with a coffee. Thank you so much, Fuzzy Puff. You are too kind. Thank you. MJS, so if Michelle is held in contempt, does she have to go to jail? I hope so. Send her ass to jail. What's up, Jonathan? If she's doing that shenanigans in the court, send her sister to jail, too. They're pulling that nonsense in court. The court, how many days have they been there already, and they're pulling that nonsense? I mean, it could be a mistrial for criminity's sake. Oh, Katie Kool-Lady, what's up? Good to see you. Thanks for stopping in.
What's the state's position on Ms. Gardner's motion?
Contempt for showing her computer to the gallery. Oh, I'll shut up.
Bond hearing on her motion. We're prepared to respond and prepared to have that hearing. I just believe that for the record's sake and for appellate purposes and to avoid prejudice to the state of Florida, we need to handle the disqualification motion prior to proceeding with our hearing. I've spoken with defense counsel this morning. I think we are close to requesting, I won't speak for them, I'll let them do that. We're close to requesting both the disqualification hearing. I've floated some dates with defense counsel. I'd be requesting we set the motions filed by defense regarding the disqualification the week of March 11th and Ms. Gardner's Arthur hearing the week of March 25th. And I think that's very reasonable given the amount of evidence the state's going to have to present to prepare, file our written response to their bond motion and handle this other pending matter.
All right, let me first hear from you, Mr. Carter. What's your position?
Judge,
On those dates.
Judge, I would need to speak to the other counsel involved in the case before I was able to confirm with the court.
Okay.
We've asked.
I mean, as far as the way that I'm reading your motion to schedule an evidentiary hearing and memorandum of law is that you believe that the state of Florida has had sufficient time. You wish to push forward regardless of the court's ruling on a disqualification. Am I reading that incorrectly, or?
No, Judge, that's our position, and one of our major concerns is if we are successful on disqualification, we'd be back before the court with the new state attorney's office, and they'd be begging the court for more time to get up to speed on the case before they could have the evidentiary hearing. So it's our position, and our first available date is March 5th, and we'd ask for March 5th, Judge.
Do you like how I got that volume booster in there? I boosted that shizzle.
So I'm looking to essentially your second sentence in the second paragraph, which says, while the law is clear that a trial judge, upon a motion to disqualify him or her, which that's not necessarily the case, you're asking to disqualify the state, must first rule on the motion for disqualification.
So, Judge, that was referencing a motion to disqualify the trial judge where it's an all stop and the judge can't rule on any other motions.
Right.
There is no case law similar for a motion to disqualify the state attorney.
So it's your position that it is not an all stop?
That is our position, Judge.
Are you taking into consideration what has been alleged against the state? And to me, it's a little bit different. So let's say it's the evidence that they potentially would produce to the court, which is one of my concerns about hearing any motion. If there's contested evidence, right? And then that would be presented in front of the court. That's what I don't know. Like, obviously I haven't seen it, I don't know. Do you have any of those concerns if we went forward with the bond hearing?
Judge, I have some concerns.
Based on your review?
But based on my review, I don't know any other way, Judge, because my client's been sitting in custody for a long time now. The state has had an awful long time to prepare for any evidentiary hearing on a bond. I mean, I think it's disingenuous for the state to say they need more time to prepare when they've already presented this case to a grand jury, and they're well aware of all the evidence out there. To our knowledge, they've completed all testing. So I wouldn't understand how they would need more time to prepare. But with regard to the the court's position about whether or not we have concerns, we do have concerns, but the alternative is that Ms. Gardner stays in custody until this disqualification issue is resolved. And I think, Judge, once you hear what we found out during the depositions this week, you're going to see that this is much, much bigger than any of us ever thought a week ago.
Oh, boy. Oh,
and
boy.
I can tell the court what happened.
Really?
Yes, Judge. I can tell the court what happened during the depositions this week if you would like to.
Let's hear it. Yeah.
So, because you share in those concerns, right? And I'm concerned, and I've always been clear about that with the parties, right? Ever since you all filed this motion with the court, to me, because there is no guidance in a situation like this is probably, I don't know if it's a first impression, but at least it hasn't been litigated on an appellate level. It seems more practical to me to handle the disqualification. I'll give you the time. I'll make the time. If you all are prepared, I wanted to do it sooner rather than later, and then I could still honor all of the things that you put into this motion. I'll give Ms. Gardner the hearing that she's entitled to.
Yes, Judge.
Right? But if you all have concerns about potential evidence that they would present in order to meet or not meet their burden, then I'd rather hear that out first. And I do understand the concern about getting up to speed. Let's say hypothetically I do disqualify the state attorney's office. I'm cognizant of that, but the state should be able to burn the midnight oil in my mind and get that prepared. So
Your Honor, this is Jesse Dreiser on behalf of Mr. Fernandez, and we didn't do our note, and Mr. Hill is present, Mr. Tassoni as well. Your Honor, I don't know how clearly I stated this in our motion to disqualify. I don't know how clear.
Mr. Bias, not all people.
Yeah.
You have to talk to the microphone.
I don't know how clearly I stated this in our wherefore clause, and I may amend to make this very clear, but it will be our position that not only are we asking you to disqualify the entire Fourth Judicial Circuit, when the governor, I assume, does the governor's assignment for the new prosecution team, we're going to want all of the electronic data to be sent to a new filter team so that there is no way that this can happen again. So that the new state attorney that gets the case has it completely sent through a filter team so they don't end up with our text messages, our emails, our attachments, our timelines, and every other thing that the state had access to and is in possession of. So that's going to be another delay that the state can't burn the midnight oil on, because that's going to have to happen in our minds for this case to be secure and non-prejudicial to the defendants.
All right. Do you want to tell me what your position is based on the discovery that you conducted?
Our position is we're ready to go. With the exception of time that we need to get the transcripts from the depositions, so I would say 10 days. The state did speak with us this morning. Their timeline was acceptable in terms of our issue. The bond issue is not our issue. That's Ms. Gardner's issue. Tangentially, though, it does affect, because what you're saying is, what if the state uses the document that I'm highly contesting, or the text messages that Ms. Gardner is highly contesting against Ms. Gardner in her bond hearing? That would pose a problem for me. Because again, it would be one more person, you or anyone else, that would have access or actual knowledge of what's in that document. So I don't have a suggestion there, but I do have the same concern that you were sharing this morning. for certain. I can't predict what they may or may not show.
Okay.
And Judge, we are going to supplement our motion as the court asked us to inform the court today. And we're going to move to actually dismiss the indictment, Judge, based on the fact that the state and its law enforcement officers, and this is sworn testimony, were reviewing both Miss Gardner's iCloud return and her Google Drive return before it ever went through the taint team, that was knowing and intentional acts by the law enforcement team that was working with the state, and that when they had questions when reviewing those about whether or not something they were actually looking at was attorney-client privilege, they would call Miss Stifler and ask her, describe it to her, and ask her if what they were looking at was in fact attorney-client privilege communications. And so it's our position that the spillage of her attorney-client information throughout the law enforcement teams, which are Category A witnesses expected to testify in this trial, will amount to sufficient prejudice that we can never put the genie back in the bottle and Ms. Gardner can never get a fair trial. I will let the court know that we have some research to do. We are not taking this lightly. We want to make sure that we are able to adequately support the assertion that I just made to the court before we file our supplement. But we do think that what we established during the depositions this week, in fact, one of the things we learned, Judge, is that my client's iMessages from her iCloud, which we all know did contain attorney-client communications, were circulated to all or most of the primary members of the law enforcement team by email before the taint agent, who was never trained and had no protocol and had never done this before he even looked at them. And that the spreadsheet with all these messages that was circulated was open and reviewed. And that the law enforcement members did in fact identify attorney-client communications in that spreadsheet, which was by another court's order, right, in February of 2023. All of that was supposed to go through the taint agent before anyone that was part of the prosecution team looked at it.
What's your job? Oh, I'm a taint agent. How are you? I'm sorry, did you say taint agent? Yeah, I'm a taint agent. Senior taint agent.
So what do you all want me to do?
Judge, I would ask for 2 weeks for us to file our supplement to the motion to disqualify. I don't know how long the state would need to respond to that. And then,
So that's still putting you off the timeline that you're indicating.
I know, Judge, but I'm stuck between a rock and a hard place. And so,
Do you want a moment to try to talk to your colleagues?
yeah, well,
Really, his client.
yeah,
my client.
Yeah, let me, one moment.
So what do? I work the taint. I'm an agent of the taint.
Judge, I've talked to my client, and we agree with the court's assessment earlier that if we can resolve the disqualification motion in a timely manner, we can then set the bond motion.
Okay.
And that satisfies the concerns that Mr. Fernandez has as well, Your Honor.
Okay. And you talked to him about it? I mean.
We're in a different posture. I don't need to talk to
Yeah.
Mr. Fernandez.
Right, well, this is the thing. You all know, I have not seen one shred of anything, and this is the other thing I was gonna ask you, is it your thought, so you're gonna supplement, right? The state's gonna respond. Is it your thought that I do need to ask the chief judge to appoint another judge to review this material, or is there an agreement on it?
I spoke to the state and Mr. Carodi, and I'm just addressed for the record. I don't believe we need another court. The emails, the text messages, everyone and their brother had them in this case, far before Next Point even became an issue. And the documents that the state intends on using against my client, they've seen, they've read, they intend on using them. If the court, if you see that document, it makes no difference. That privilege has been eviscerated unwillingly by the defense, and I would say that if there was any concern for the court, I would waive any ability to recuse the court based on this very limited issue, because, you know, if the court has some concern, like, well, then I'll see it and then the defense will try to recuse me. Absolutely not. I think this court is the proper place to hash all of this out.
All right. Am I understanding? Before, there was an agreement that certain documents, certain communications, those things, my understanding was there was a great majority of the information that you all were talking about was agreed to by the state of Florida, that was attorney-client privilege. Is that still the case? Or are you still, my understanding was only kind of one document or thing
Right.
on Mr. Fernandez's part. But the state indicated it was evidence. This defense said it was attorney-client privilege. And it was my understanding, it was only one contested document. Is that still the case?
There's
Right,
there's one contested document that the state is in possession of, admits that they've looked at and intends on using. That's what you're speaking of specifically.
Right, and so I'm
There are-
asking, is that still the case, yes or no?
Yes, there are hundreds of what the state agreed to were privileged communications that were uploaded to Next Point that the agents had access to. Their position is, yes, they were privileged.
Get the taint agent in here now. I want to hear from the senior taint agent.
But no, we have never looked at them. No one has ever looked at them, albeit everyone had access to them. Their position is no one's ever seen them, except for the one document. So
Right, so I can clarify, sorry, I know, I don't mean to interrupt Mr. Geisler.
You're fine.
But I somewhat agree with what's being said. I do think that the depositions made clear, and that's been, the information brought out depositions is the information contained in the state's filed written response. But we have been clear from the beginning, there was an agreement between parties to send cell phone devices, MacBooks, Apple Watch, and an iPad through a taint team. The Jacksonville Beach Police Department executed over 70 search warrants in this case, including to Google and to iCloud. They received that information directly as the affiant custodian of those records. Those records are at Jacksonville Beach Police Department, just like any other evidence for any case we stored with the presiding law enforcement agency. There is one document that we discovered while reviewing this evidence that I believe is evidence. I don't believe it's one, it's a communication, or two, it's confidential, or in any way a privileged attorney-client communication. That document was brought to my attention by our analyst. I reviewed it. I determined that there was nothing about it that suggested it was from an attorney to an attorney, etc. I mentioned it to Mr. Dreiser, and we are disputing that one document. The rest of what they're talking about is the state of Florida never had possession of any of these items. They were in the possession of the law enforcement agency. Once we realized that there were attorney-client privileges, documents, or text messages on this information, which we have purposefully taken folders, left them sealed and zipped and didn't review them. The analysts were reviewing other evidence that was not attorney-client privilege. Those were then sent through the taint team. The state of Florida and law enforcement has never read any emails, any text messages, any client communications other than this one document. The state attorney's office agrees. I read this one document, I intend to use it. So I just want to be clear about all of that because Mr. Perotti is saying he wants to dismiss the indictment and needs to do research to adequately support his assertions. I just want to be clear, at this point they're assertions. We have I haven't seen their supplemental motion yet. I think I have previously said that the communications, I took Mr. Dreiser, Mr. Perotti, Mr. Bias's word that whatever emails and text messages were privileged, I took their word that they were privileged. We didn't look at them, we removed them, we deleted them, we sent them through tape teams. To the best of our ability, we tried with good faith never to purposefully or intentionally read anything. Any disclosures or any possessions were inadvertent, and we took whatever steps to remediate our possession of these when we realized that we had things we were not supposed to have in
Can
our
I
possession.
ask you a question? Do you believe, based on what Mr. Dreiser is saying, okay, that the court could just look at metadata and not the exhibit? Do you understand what I'm
I
asking?
understand what you're saying.
So
I don't think you-
file, give me a second.
Yes, ma'am.
So file A, okay, if I don't need to see the contents of file A, that's why I'm asking you all this question. I don't see the content of it. if you all agree that it is in fact attorney-client privilege, there will be no need for the court to examine that document, then to determine if whoever had access to it. That's what I'm asking. Are y'all agreeing or are you not agreeing? Or is the agreement just as to one document, or are you all saying it's multiple documents? And if it's multiple documents and there's no agreement, I'm gonna disagree with you, Mr. Dreiser. In an abundance of caution, I ask the Chief Judge to have someone else review it, settle your disputes, and then I'll look at the metadata.
And Your Honor, my response to that would be, I have not seen anything or reviewed anything other than the document we're disputing is privileged.
Two documents.
2 documents. Actually, one of them I reviewed, one of them I was told about the contents. I have not seen or reviewed any of the, I think he said 66.
It was also
emails.
sent to you in the same email,
Yes.
2
So
documents.
y'all will talk to each other. Is there an agreement or is it not?
It's a little bit more complicated. I know,
I'm not
we're not in agreement that the one document, that is going to have to be reviewed by the court. The
Okay.
other documents, which are emails, text messages, and phone calls, there are over 100 at least communications. There's no question that they're privileged, and there's no question that they were uploaded to NextPoint. The only and I wouldn't allow, it would be over serious objection by the defense, that anyone ever get to look at those. So no court is ever going to get to look at
Okay.
those.
Give me a moment. Do you agree?
I do not. I believe that part of their argument, because my testimony and our response and what I believe will come out of the hearing, is nobody from law enforcement and the state attorney's office looked at any of those items that they're talking about, the text messages.
I agree with
the
that.
emails.
So why aren't you agreeing that they're attorney-client privilege?
Because I don't know what they say, and I don't dispute that there are communications between them and their clients. My issue is the prejudice, which is the second prong of their motion. If these emails and text messages are about scheduling, and the court's going to disqualify and dismiss an indictment because we had theoretical access that we could potentially hypothetically open a scheduling text message, I think the court needs to weigh that of how prejudicial the mere access is. Putting aside the fact that we didn't read them, the fact that I have a closed sealed envelope on a table next to me, it matters to me what's in that envelope because they're saying it's a communication. I'm not disputing that. I take them at their word. But what it contains is relevant to the remedy that they are seeking because they have to prove that they've been materially prejudiced in some way. The state of Florida has somehow inured a benefit to trial by having access to this information, that I will have evidence I should not have had, that I will have trial strategy I would have otherwise not known. So I believe that an independent magistrate should review it. And I will point out that when we had this agreement in front of Judge Carbula on their motion for protective orders to stop us from doing a forensic extraction of the phones, they were in favor of a magistrate reviewing everything. So at some point, we were all in agreement to detainting. They wanted a magistrate to review all the communications and remove attorney-client
Did she say
and marital
detainting?
privilege. The court said, no, the state can look at marital privilege. There was no court order. We agreed. We are not going to look at attorney-client privilege. We don't want to look at it. We have no intention of looking at it. Anything that has happened has been inadvertent and has not prejudiced them. So the contents of those messages are relevant to that prejudice, that finding of prejudice or non-prejudice.
With the exception of 2 documents
Yes, and I'm
titled
conceding
confidential communications sent by Miss Butler to Miss Stifler
Stifler's
before
mom?
the taint agent ever got a chance to look at them. And our expert's going to come in
I'm fine
here.
with the court reviewing those 2 documents because I don't believe their communications are privileged.
Our expert's going to
They're contesting that.
And our expert's going to come into this courtroom and say that on such and such a date, Mr. Fernandez emailed our office and our attorneys only those documents. The taint agent is going to come in and say, had I seen the email with the attachments, they would have been privileged.
I just got to apologize. If you are looking for a stream that's going to have coverage of court trials that doesn't point out Stifler's mom or Tate agents, you're just on the wrong stream. I'm sorry.
And I would have filtered them
I can't
out.
let it
That's
go.
what we heard this week in the testimony.
All right. It is very clear to me that sooner rather than later, and when I say sooner, does Ms. Gardner share the same concern?
Judge,
With the same,
our concern is slightly different in that, Ms. Stifler spoke about there was an agreement with the cell phones and somehow that agreement didn't apply to her iCloud that was seized after the agreement that everyone knows has the same text messages that are on her phone. And so I guess what I'm hearing the state say is that because law enforcement couldn't look at the phone, they went and got her iCloud.
I just want to be clear
Okay.
about that. What I'm saying is, we had an agreement, we attempted to honor it, we were dealing with hundreds and hundreds and hundreds of megabytes of data. We did our best to send it through the filter team. We made efforts, extensive efforts to prevent disclosure of attorney-client privilege. The 2 documents he's referring to are just evidence. I had no idea they were emailed to Mr. Gardner by his client. I found them from an independent source. But I just want to be clear because they keep saying these things on the record that I dispute. And I just want to clarify the record. I think that we need an independent magistrate to review everything because I think that prejudice needs to be determined. And if Mr. Dreiser and I are agreeing whether the contents of this document are even a communication, then I'm not comfortable with Your Honor reviewing it.
I've said this from the outset. A court hearing a case of this magnitude, okay, I want to avoid any appearance. I appreciate the,
It's fine. We don't
I
object.
appreciate the thought expressed by you, Mr. Dreiser, but my concern runs deeper than that, okay? So I've said it from the outset. I'm the one that offered it. I've talked to Chief Judge Day, and he's willing to expend the resources. However, I am going to request, it is very apparent to me that that is a necessity. And I am also cognizant of the time frame and the work that all parties have put into it, both the defense and the state attorney. That's why I need a clear understanding of where your agreements are, where your disagreements are, because I don't want to send this to another judge with you all still essentially disputing or arguing about what the magistrate is or the other judge is going to look at, okay? So, I'm going to ask the chief judge to appoint another judge to review these materials. I don't want to have access to it. I don't want to review it for a number of reasons, and I think it's only judicious and fair that if it is contested, what these documents are, whether they're privileged or not, a judge then ultimately, let's say we go through hypothetically an entire trial, there would be no way to any imposition I would have. Like, I don't want to have access to something that apparently or may not rightfully be a part of this case. What I do need the parties to do is based on your discovery. So we have these initial motions. Ms. Gardner says she's going to amend. Mr. Dreiser, are you amending or no?
If I did, it would be of no real significance, just to make sure my remedy is clear and maybe add what we believe we learned in the depositions. It would not be of any significant,
Okay.
but I'll have it done whenever.
This is what I need you all to do. I need you to supplement both pleadings with what is in fact contested, okay? What is agreed to and not agreed to. The agreement should be, in my mind, the first part of the supplement. These now 2 documents that the state has admitted you are, and so that is the first part. The second part should be what you all do not agree to, what you want the magistrate to look at, so you can, out of this terabytes and terabytes of information, to hone in. And this is all for efficiency, and also if you want a decision done quickly, that you all kind of narrow the issues for the judge. I'm going to ask the chief judge to make the appointment. He should be able to do it hopefully by the beginning of next week. I need you all to supplement. How long would you all need to identify those things?
Despite how we're talking on the record today, I think for the most part, we actually agree on a lot of
I-
information.
I agree with that.
So
Oh, that's not the impression you've given me.
That's my morning report. Actually, Mr. Dreister and I, Mr. Purdy, I spoke this morning. I think a lot of these things there's little dispute as to certain pieces.
The
of
woman on the
evidence.
right
Dispute is to the law and the remedy.
is,
So we will get together
was
and
Jared's
we'll come
wife.
to some
So-
understanding.
when he was
Man.
What
murdered.
I'm understanding from you is that you want the magistrate to, or the judge to look at certain portions that you have not seen in order to say if it's to separate that these documents or these files or these, whatever it is, this is related to scheduling, therefore,
Right, I don't know what they are, but I think it is germane to their remedy they're seeking as to whether it prejudices them or not. The fact that I merely have access to their scheduling, I mean, I'm using that as an example because obviously I don't know what's in there. But it makes a very big difference if they're discussing their trial strategy versus if they're discussing scheduling.
from your deposition, were you able to kind of like narrow that down, or is it just hundreds and hundreds of files or things, or?
I narrowed the scope of the depositions to the documents that are in dispute. The other emails,
How about we start with that?
the other
What do you
email,
all think about that?
here's the
Start
problem.
with that.
Here's the real next big issue with another magistrate reviewing all the emails, which in a vacuum, I don't have a problem with it. That magistrate, what Mrs. Stifler was referring to in the initial hearing, was going to be a magistrate, a special prosecutor, or a filter team person. I would have had no problem because they're totally isolated. And I assure you that person would have never reached out to Ms. Stifler to find out whether something was or was not privileged. But in this case, if the magistrate's going to do that, and the magistrate may have, or the circuit court judge, whoever Judge Day appoints, and then has questions, the state attorney's office is going to have to bring in a special prosecutor to handle those hearings. It'll be like a federal castigar hearing, where the AUSAs have a whole nother team to handle the hearing, because during that hearing, they would be potentially accessed or being asked questions or being asked to argue
Go
that.
back to my original question.
Yes.
What about, we start with the two documents that you all contest,
That's fine with me.
and then we table what Ms. Stifler is suggesting.
Sure.
Then you all don't have to supplement, you all can identify, we know what it is, right?
Absolutely. There's no confusion about those documents, who had them, when they had them, what they intend on using. That would be very simple for this. There still needs witnesses and a hearing to hear the timeline. But yes, we can absolutely start there, Your Honor, and perhaps finish there.
That seems more prudent.
Yes, ma'am.
I'm
Do you agree?
in agreement.
There we go. It happened.
Told you.
Where's Ms. Gardner in all this? Do you agree or no?
Yeah, Judge, we're going to supplement. I think our basis is going to be a little different, and that is, we believe that what we would call the state's effort, and by state we mean the law enforcement team that's working with the state attorney's office, right? One state organization. That our concern is the effort to do an end around the court's prior order regarding the taint team by looking at the iMessages from the iCloud and the Google returns. So I don't think there's a dispute that there were attorney-client communications on, on those returns.
Is this something that you discovered during the depositions?
Yes, we had no idea. We had no idea that anyone had looked at her iMessages before the taint team was, or taint agent, because it wasn't a team, it was one agent.
Now I'm going to ask you all this: if to settle that issue, would you like another judge to hear that, or can you agree, or would you rather me deal with it through the metadata?
I think for that issue, based on what the deposition entailed with Ms. Butler, which this was outlined in the state's written motion, so to me at least it was not a surprise. She discovered an attorney-client communication while reviewing something and realized it hadn't been properly detainted, and then we sent it. That one communication, I think an independent magistrate could review. I never reviewed it, I don't know what it contains, but she could tell that judge in camera what it was without the state attorney's office present, and I'm fine with that.
Do you agree?
Yes, Judge.
Okay. let me ask this. Have both defense teams seen that? Do you want a separate hearing for each defendant, or do you want to have it concurrently?
When it comes to their messages, I don't know
So
what
you're
it
requesting
is.
separate hearings?
Yes, Judge.
Okay. All right.
Yeah, maybe, Your Honor, for judicial economy, a lot of the same witnesses, it may be the same hearing for evidence, and then just like a Castigar hearing, I would be asked to be removed for a portion of the hearing.
Obviously, I'm not going to conduct them, so I'm just trying to
Okay.
be as detailed as I possibly can with the request that I'm asking the chief judge to do so that he can communicate and figure out who he would like to appoint. So what I'm asking, what would be required of the other judge, which is my understanding, which I'm going to repeat back, is that you all have a contested document on Mr. Fernandez's behalf, two contested documents. And then on Ms. Gardner's behalf, there is a communication that was not, that was communicated to law enforcement and.
Two documents and one
Communication.
message or text or something.
And I don't know exactly what the ATF analyst reviewed because I obviously did not ask her that in an open deposition. So it would be a questioning for the ATF analyst exactly what she has reviewed.
All right.
And because I know that the iMessages were circulated amongst at least 4 law enforcement officers, I do not know yet if any of them reviewed them also before the detained agent was able to go through. In full disclosure to the court, we may stumble upon someone that's reviewed more than the ATF analyst.
You didn't ask those questions during the depo?
So-
How, if it was communicated to anyone else, or whether she talked to anyone else?
Well, the problem is what she said is that she got the iMessages in an Excel spreadsheet that was emailed to her, and that there were detectives and other federal agents on that email. Obviously, she can't speak to whether or not those other people that were on that email did in fact review the iMessages. We've not deposed those individuals. I don't believe I've gotten a copy of the email that was originally distributed to know who exactly was on that email.
I can get it, I can make those people available. I will say, I mean, they can check them out, I don't have to take my word for it, but Ms. Butler was our analyst, so she was always the first and only person to receive and begin analyzing the evidence before everybody else did. So it's unlikely, but obviously I will provide those.
Good view of his elbow. Good camera work here. I've been wanting to see his elbow this entire time. I'm so glad that they did that.
How long, I'd like to do this sooner rather than later.
We
Do
need
you want to come back next week?
for the.
Or, so, based on my understanding and the parties, Ms. Gardner is going to supplement, correct?
Yes, Judge.
All right. How long do you need for that?
Judge, I'd ask for 2 weeks.
Okay. In the meantime, I will ask the chief judge to appoint an independent judge from this case. When do you want to come back for your?
To set, all we need really is the 10 days for the transcript.
When did the depo occur?
Tuesday and Wednesday.
Me to see you all. The appointment can be made, and then the scheduling would be with the other judge. I can put this on for status.
Yes, ma'am.
Yes, Judge.
So you need 2 weeks. You need time to get the transcript, which it looks like, by my count, the earliest the transcript would be ready would be February 29th. If I count 10 business days, if you ordered it.
We did, and Miss Butler chose to read. I don't know how that delays or not.
Okay. So, would you all be prepared to supplement without the transcript or no?
Judge, I believe we would based on my notes from the deposition.
Okay.
So I'm about to end this because it looks like they're going to put it over, and we're going to go to the Troconis trial. If you guys did not see what happened yesterday, Michelle Troconis apparently is pulling stuff up on her laptop that the gallery can see that is discrediting the expert on the stand. Additionally, her sister is apparently mouthing stuff to the jury. So at 10 o'clock, the judge is coming in, and there might be he might hold her in contempt. So that's where this stream is going to go. And for folks who came in late to this hearing, from what I can gather, and I'm no lawyer, I'm just a moron yelling at a screen. From what I can gather, the defense is making a motion to get rid of the entire prosecution team because they, while they were doing discovery, somehow got attorney-client privileged communications that they saw, and at least 4 agents saw, that they should have never seen. And now we got to get the taint team involved. So, I mean, it sounds right now they're just going to be rescheduling. Let's just see. There's going to be another appearance.
The appointed judge, okay, to review. I'm assuming that judge will need time in order to process and do an order. I can come back
March 4th?
March 4th, anytime that week, or the week of March 11th, you can let me know where you are with the other judge, if you want me to do that, or I'm just going to set this for a status at this point.
March 4th for a control date to see where we are with the other judge would be fine with the defense team, Your Honor. Yes, Judge.
Okay.
All right, can we do March 5th? The co-defendant is set to appear on March 4th.
I'll reset this date.
Perfect.
You want the 4th?
Yes, ma'am.
All right, March 4th, folks. We'll be back here. This is going to take us...
The status on the Tenon case, knowing that these cases would dictate a court date for him, okay?
All right, thank you all so much for being here. We'll be right back. This is going to portal you over to the stream for Troconis. We're going to portal over there. Going to end this, and I'm going to be in that stream. Join us over there. Thanks so much, everyone, for being here, and I'll catch you on the Troconis case.